Hello everyone, today we are going to see the chapter Unpaid Seller. Meaning of unpaid seller. According to section 45 of Sale of Goods Act 1930, a seller is deemed to be unpaid when whole of the price has not been paid or tendered and the seller had an immediate right of action for the price. Means whole of the price is not paid. Even if 99 rupees is paid, 1 rupee is not paid, he will be called an unpaid seller. When a bill of exchange or other negotiable instrument has been received as conditional payment, when we have received any bills of exchange or negotiable instrument like check and the condition on which it was received has not been fulfilled, we have received check on the basis of the condition that we will be clearing it, but the condition has not been fulfilled and by reason of the dishonor of the instrument or the otherwise and has been dishonored, so in that case also it will be called an unpaid seller. The term seller includes any person who is in the position of the seller as an agent, consignor, agent who has himself paid or is directly responsible for the price. So seller and this agent, consignor will be also called the seller. Ravi sold a laptop for 60,000. Buyer paid 59,999. Can Ravi still be treated as unpaid seller? Yes, since the whole price was not paid. Buyer gives check for full price. Check dishonor. Is seller unpaid? Yes, because check is an conditional payment and it got dishonored. Buyer paid full amount in the cash before delivery. Can seller be unpaid? No, because whole price was paid. Transport agent sells goods on behalf of the owner and is personally responsible for collecting sale price. Can he be treated as seller under section 45? Yes, section 45 includes such persons who is responsible for collecting the price, like transport agent. P sold machinery to Q. Q paid 50% immediately and promised balance after 1 month. Before due date, Q became insolvent. Can P be treated as unpaid seller? Yes, because whole price was not paid. Insolvency does not change the status. Now P sold the machinery to Q. Q paid 50% immediately and promised to pay balance after 1 month. Before the due date, X became insolvent. Can B be treated as unpaid seller? Yes, because 50% still was not paid. Whole price is not paid, conditional payment and dishonored will be called unpaid seller. 90% paid means seller is not unpaid. Even 1 rupee unpaid is enough. Check means payment completed. No. Check is conditional payment. Dishonor restores status of unpaid seller. Only the owner can become an unpaid seller. No. All these are trap. Agent, consignor who is personally liable for the price is also unpaid seller. Ignore these sources. Mr. D sold goods to Mr. E for 5 lakh on 15 days credit. Goods delivered on due date. Mr. E refused to pay. State the position and rights of Mr. D. So Mr. D is an unpaid seller. What are the rights of Mr. D against the buyer? Goods are delivered. So this we will see in subsequent unit. He can sue for the price, he can sue for damages, he can sue for interest. What is position of seller when a check received as payment is dishonored? Seller becomes unpaid seller as check is conditional payment. Dishonor of check makes the conditions fail. Is partial payment sufficient to make seller not an unpaid seller? No. If an part of the price is paid, seller remains unpaid seller till the whole price is paid. Ignore these. Whole price unpaid seller. Dishonored check unpaid seller includes agent, consignor, who are personally liable for collecting the price. Rights arise before after becoming unpaid seller. Only after becoming unpaid seller you will have the rights. Ignore these. Unpaid seller, rights of an unpaid seller. Once you have become an unpaid seller, you will be having the following rights. Subject to the provisions of this act and of any law for the time being enforced, notwithstanding that the property in the goods may have been passed to the buyer or not. So property of the goods has been passed to the buyer or not. The unpaid seller of the goods has an implication of law. What he has? A lien on the goods. Right to lien on the goods for which price while he is possession of them. When he is possession of the goods, he can have the right to lien. He can have right to lien on the goods. In case of insolvency of buyer, a right of stopping the goods in transit after he has parted with the possession of them. So once he understands that buyer has become insolvent and he has parted with the possession of the goods, buyer has become, their condition like buyer should become insolvent and he has parted with the possession of the goods, then he has right to stoppage in transit, stop the goods in transit. Right of resale has limited by the act. What is right of resale? Subject to conditions of the act. Where the property in the goods has not passed to the buyer, the unpaid seller has, in addition to the other remedies, a right of withholding delivery similar to and coextensive with the rights of lien and stoppage in transit, where the property has passed to the buyer. So when the property is not passed to the buyer, he has extra right of withholding the delivery. Unpaid seller has been expressly given rights against the goods as well as the buyer personally, which are discussed as under. So he has right against the goods, which is right of lien and right of stoppage in transit and right of resale. These are against the goods, and against the buyer he has rights called rights for price, rights for damages, rights for interest. State the rights of unpaid seller as per the section 46 of Sale of Goods Act. Right of lien, when he is possession of the goods. In case of insolvency of buyer and he has parted with the possession of the goods, he has right of stoppage in transit, where a right of resale limited by the act. Where property has not passed to the buyer, unpaid seller has right of withholding delivery similar to and coextensive with the rights of lien and stoppage in transit. Can the unpaid seller exercise right of lien after he has delivered the goods to the buyer? No, he should be in possession of the goods. When can an unpaid seller exercise right of stoppage in transit? When the buyer has become insolvent. Is the right of resale absolute for the unpaid seller? Right of resale is conditional. It is subject to the provisions of the act, that is notice to the buyer. Notice should be given. It is not absolute but is conditional, like limited to the act. If the property in the goods has not passed to the buyer, what additional rights does the unpaid seller have? Right of withholding the delivery, which is similar to and coextensive with the right of lien. Mr. X sold goods to Y for 2 lakh on 30 days credit. Before the expiry of credit period, Y becomes insolvent. Goods are in transit. State the rights of Mr. X. Mr. X right of stoppage in transit as Y has become insolvent. P sold goods to Q for 1,05,000 15 days credit. P delivered the goods to Q. Q did not pay the price. What right does P have? So P sold the goods to Q. P delivered the goods. P is not in the possession of the goods. Q did not pay the price. So he has right to against the buyer, not against the goods. He has against the buyer right for suit for price, suit for damages for not acceptance, suit for interest. This we will discuss later. Discuss the rights of an unpaid seller in brief. Rights of unpaid seller: lien, stoppage in transit, and right of resale. If the property has not passed, also right of withholding the delivery. Unpaid seller has 3 implied rights under section: lien, stoppage in transit, resale. Property has not been right of withholding the delivery. Lien only when in possession, stoppage in transit only if the buyer becomes insolvent. Resale is not an absolute right, it's a conditional right. Right of withholding delivery only if the property has not been passed. Seller's lien. So we will see the first right, which is seller's lien. Unpaid seller has a right of lien on the goods for the price while he is in possession of them until the payment or tender of the price of such goods. So he can retain the goods until the price has been paid. It is right to retain the goods and refusal to deliver them to the buyer until the price due in respect of them is paid or tendered. It is possessory lien. A lien can be exercised as long as the seller remains in the possession of the goods. Seller may exercise his right of lien even where he is possession of the goods as agent or bailee for the buyer. If he has received the goods as agent or bailee, if he is in possession as agent or bailee of the buyer but he is called an unpaid seller, then he can exercise right of lien in the goods. The right can be exercised by the seller in the following cases only: where the goods have been sold without any stipulation of credit, that is cash sales, and the price has not been paid; where the goods have been sold on credit but the term of credit has expired. 3 months credit is given. We cannot say unpaid seller if 2 months is only expired. The entire 3 months must have expired, where the buyer becomes insolvent. If still 2 months have expired and he has become insolvent, then also we can call it as unpaid. A person is said to be insolvent who has ceased to pay his debts in delivery, ordinary course of business, or cannot pay his debts as they become due, whether he has committed an act of insolvency or not. State the meaning of seller's lien as per section of sale of goods. Unpaid seller has right of lien on the goods for the price while he is in possession of them. He may retain the goods and refuse to deliver the goods till the payment or tender of the price. It is a possessory lien and can be exercised as long as seller remains in the possession of the goods. Can seller exercise the lien after delivering goods to the buyer? No. Possessory lien ends with the possession ends. Can lien be exercised if the goods sold on credit and the term of credit has not expired? No. In these cases, it should have expired. Then only he can. This is not for unpaid seller. Then only he can exercise the lien. Can lien be exercised if the buyer becomes insolvent? Yes, insolvent is one of the cases. Can lien be exercised if goods sold on credit but buyer pays part of the price? Yes, lien can be exercised for unpaid balance. A sold 100 bags of cement to B for 45 days credit. Goods were kept in A's godown. After 50 days, B neither paid the price nor took the delivery of the goods. Later, B became insolvent. Can A exercise right of lien? Yes, A can exercise right of lien. Goods are still in A's possession. Term of credit has expired. Buyer has become insolvent. Conditions of liens are satisfied. Okay, what is right to retain goods till the price? It is possessory lien. When exercisable, cash sale, credit sale. When expired, buyer becomes insolvent. Needs possession? Yes, as long as seller is in possession of the goods, then only he can exercise the lien. Yes, even in can be if he is in possession as agent or bailee. Yes, even in such cases he can exercise the lien. Keep it till I get my entire price. No delivery. Lien after delivery? No. Lien before credit expiry? We cannot do. Lien without possession? No. Lien means retain while in possession. Seller's lien is right to retain the goods. Exercisable in 3 different situations. It is possessory lien, ends when the possession ends. Insolvency is one of the grounds. Part delivery. Where the unpaid seller has made part delivery of the goods, he may exercise his right of lien on the remainder, unless such part delivery has been made under circumstances as to show an agreement to waive the lien. See, what is part delivery? He is giving part delivery and part delivery is with him. So now he can exercise lien on this part delivery, unless when he cannot do, unless by delivering the goods he has waived the lien, unless such part delivery has been under circumstances as to show an agreement to waive the lien. Unless he is told that I am delivering you the goods, part delivery, which means I am waiving the lien. It should not be like that. He should not have given such agreement to waive the lien. If he has given agreement to waive the lien, if he has given part delivery as an agreement to show that he has waived the lien, then he cannot lien on the remaining goods. Otherwise, he can lien on the remaining goods. If seller delivers only a part of the goods to the buyer on cash or credit, he still has lien on the goods which are still in the possession. This right is available unless the part delivery was made under circumstances showing an agreement to waive the lien. Waiver can be expressed or implied from the conduct or the terms of the contract. Lien can be exercised only on the goods which are still in the possession of the seller. No lien on goods already delivered. If the circumstances show intention to waive lien, seller cannot claim lien on the remainder. Seller agrees in contract that even if the price is not paid, balance goods will be delivered. This shows waiver. See, even if you are not paying the price, balance goods will be delivered. This is waiver. So part delivery is not loss of lien. Lien continues on the remaining goods unless waived. State the provisions of the section 48. Where unpaid seller has made part delivery of the goods, he may exercise his right of lien on the remainder unless such part delivery has made under such circumstances as to show agreement to waive the lien. If seller delivers part of the goods and buyers paid full price for that part, can seller claim lien on the rest? Yes, lien is on the remainder, not on the delivered. Is lien available on the goods already delivered? No, lien not available on the goods already delivered, but only for the goods which are still in the possession. When will lien on the remainder be lost? When the part delivery made against circumstances showing agreement to waive the lien. A sold 500 kgs of sugar to B on 30 days credit. A delivered 200 kg immediately and kept the remaining 300 kg in his warehouse. After 20 days, B became insolvent and did not pay the price. There is no agreement to waive the lien. Can A exercise right on the remaining 300 kg? Yes. Yes, A can exercise lien on the remaining 300 kg. A has made part delivery, but he still retains possession of the remainder. There is no agreement to waive the lien. Therefore, A has right to lien on the remainder of the goods. Lien on the remainder after part delivery, no agreement to waive the lien, goods still in possession of seller, goods already delivered. What is the purpose? To secure payment of the price. Termination of the lien. When will be lien terminated? The unpaid seller loses his right of lien under the following circumstances. When he delivers goods to a courier, when the lien is terminated, lien कब खत्म होता है? When he delivers goods to the courier or other bailiff for the purpose of transition to the buyer without reserving the right of disposal of goods. So he is not reserving right of disposal of goods. What is right of disposal of goods? Means he will deliver only goods to the buyer only upon payment. He is keeping some condition for delivery. When he has delivered the goods to the buyer's place, and the goods will be delivered to him only if he pays the price or he fulfills certain conditions. That is called right to reserve the right to disposal. This is called reserve the right to disposal. If there is no such conditions, there is no reserve the right to disposal. So if he delivers the goods without reserving the right to disposal, means that is, and he puts into the transmission of the goods, where delivers the goods to a carrier for the purpose of transmission to the buyer without reserving right to the disposal of goods, that means his lien has been terminated. Where the buyer or his agent lawfully obtains possession of the goods. When the buyer obtains the possession of the goods. Where seller itself has waived the right to lien by estoppel, where the seller so conducts himself that he leads third parties to believe that the lien does not exist. He, by his conduct, expresses by estoppel that lien does not exist. Then lien will not exist. Lien continues only while seller retains possession and does not by act or omission indicate that he is giving up his right. The unpaid seller of the goods having an lien thereon does not lose his lien by reason that he has obtained a decree for the price of the goods. Yeah. Suppose he has obtained the decree from the court for the price of the goods. Still, he can exercise lien on the goods. Suppose the court has told that you will get the price of the goods. Court has told us that you will get the price of the goods. Still he is not believing the court. He can still retain the possession of the goods until the price is paid. Even if the seller has taken a decree under a court case, he can still exercise his right of lien on those goods. Delivery to carrier without reserving right. If the seller sends goods to the buyer through carrier bailey without reserving the right to lien is lost. Buyer or agent obtains possession. If the buyer or his agent lawfully gets possession, the seller's lease automatically ends. Waiver by seller. If the seller intentionally gives up his right of lien, he cannot claim it later. If seller's conduct statement leads others to believe that he will not enforce lien, he is stopped from claiming it. Lien is not a permanent right. It continues only till the seller retains the possession and does not act against it. Any act showing intention to give up the lien will terminate it. Exception includes that mere filing a suit, obtaining decree does not take away the seller's lien. When does the lien get terminated? If seller delivers goods to the carrier. When he delivers the goods to the carrier without reserving the right of disposal. If the buyer's agent lawfully takes possession, what is the effect on the lien? Lien gets terminated. Can seller claim lien after he has waived it? No. Thus, obtaining a decree for the price terminates the lien? No. State the circumstances of unpaid seller loses his right of lien. When he delivers the goods to the carrier or its bailey without reserving the right of disposal. When buyer or his agent lawfully obtains the possession, seller waives the right of lien or by estoppel. However, lien is not lost by merely obtaining decree for the price. A sold 50 bags of rice to be on credit. A sent the goods to B through a carrier without reserving the right of disposal. B did not pay even after the due date. A claims lien on the goods. Is A entitled to lien? No. A delivered the goods to the carrier without reserving the right of disposal. Hence, lien is terminated. A can claim other remedies, not lien. Goods with the seller. Lien continues. Yes. Goods sent to the carrier without reserving right. No. Buyer lawfully gets a possession. No. Seller waives lien. No. By estoppel. No. Seller gets decree of the price. Yes. Lose on delivery to the carrier. Lien. If buyer agent takes the possession, ends by waiver, not by decree. Right of stoppage in transit. Right of stoppage in transit means right of stopping the goods while they are in transit to regain the possession and to retain them till the full price is paid. When the unpaid seller has parted with the goods to a carrier and the buyer has become insolvent, he can exercise the right of asking the carrier to return the goods back or not to deliver goods to the buyer. So, when he has parted the goods from location for transferring it to the buyer, he has parted with the possession of the goods and he suddenly found out the buyer is insolvent. What he can do is he can call the carrier and say that stop in transit, stop the goods, and he can claim back the goods. Return goods back or not to deliver goods to the buyer. This right is extension of right of lien because it entitles the seller to regain possession even though seller has parted with the possession of the goods. This will only be applicable when the buyer has become insolvent. Conditions for exercise of the right. The seller must be unpaid. He must have parted with the possession of the goods. The goods are in transit. Buyer become insolvent. The right is subject to the provisions of the Act. Right of stoppage in transit. Regain possession when the buyer is insolvent. State the conditions under which an unpaid seller can exercise right of stoppage in transit as per section 50. The conditions are: seller must be unpaid. He must have parted with the possession. The goods must be in transit. Buyer has become insolvent. Right is subject to the provisions of the. What is meaning of right of stoppage in transit? Right to stop the goods to regain possession and retain till full price is paid. Is insolvency of the buyer necessary? Yes, buyer must have become insolvent. Is the right available if the goods are not in transit? No, goods must be in transit. Is this right the same as lien? No, this is an extension of the right of lien. A sold 100 cartons of books to B on 60 days credit. A delivered the goods to a transport company to send to B on another city. After 10 days, B became insolvent. The goods are still in transit. Can A exercise the right of stoppage in transit? Yes, A can exercise. Conditions: A is unpaid. He has parted with the possession. Goods are in transit. B has become insolvent. Right is subject to the provisions of the Act. Right to stop the goods in transit and regain possession till the price is paid. When arises when seller is unpaid, goods are in transit, buyer becomes insolvent. Extension of right of lien to regain possession of the goods even after parting with the goods. Seller must be insolvent. He must have transferred the goods on the way. The buyer must be insolvent. Provisions of the Act will apply. Right of stoppage in transit is a powerful right available to the unpaid seller. It can be exercised only when all the 5 conditions are satisfied. Exercised by notice to a carrier or by taking the possession. How he can do? Yeah, now this point is how he can exercise stoppage in transit. He can either give notice to the carrier or by taking the possession of the goods. Help seller protect his interests when the buyer becomes insolvent during transit. He can give notice. Notice should be given in such a way that it is not late and the delivery has already been passed to the buyer. So he can give notice or by taking possession. He can tell carrier to either stop or he can come and take the possession of the goods. Next we will see duration of transit. When will the transit comes to an end? This we will study in part 2.